century and a half, one institution has stood at the center of Ghana's legal and democratic journey. From colonial rule to independence, through military interruptions and into constitutional democracy, the Supreme Court of Ghana has remained the final arbiter of justice. But its story is not just about law. It is about power, resistance, and the enduring search for fairness. The journey begins in 1876. Established as the Supreme Court of the Gold Coast, the court began as an instrument of colonial administration. English common law shaped its decisions, often sitting uneasily alongside customary systems. But even within this framework, a legal tradition was forming, one that would later define an independent nation.
The idea of a Supreme Court actually occurred in the 19th century when the British Empire was at its height in terms of expansion and consolidation.
Before the Ordinance of 1876, we had our own colonies of customary kingdoms, which were local, and the chiefs and their council of elders were administering justice in accordance with customary law of each community. Now, we had the English law, because by then we had made contact with the Europeans, and by 1853, we had become a formal colony of the British. And then in 1876, this ordinance introduced English law to be the dominant law throughout the colony. So the significant thing about this ordinance is that it's enabled us to interact with the international world at the time, that they could also realize that if you are coming along to do any business with us, if there was a dispute, the dispute will be resolved in accordance with principles that you would be familiar with, especially for the English and the Europeans. And it served us so well that when we got independence, we decided to extend the principles of English law throughout the whole country.
And when Ghana became independent in 1957, we pretty much still had that arrangement until 1960, when Ghana was declared a republic, and Ghana didn't have to, in terms of the Supreme Court, didn't have to defer to any court outside Ghana.
Independence brought freedom, but also new tensions. With independence in 1957 and the Republic in 1960, the court entered a new phase. No longer an extension of empire, it now faced a powerful executive under President Kwame Nkrumah. The defining test came in the Preventive Detention Act cases, the PDA cases.
Fundamentally, this law allowed the executive to detain any individual, right, who they deem as a threat to national security or the national interest.
These cases asked a critical question. Can the courts challenge executive authority when individual freedoms are restricted? The answer revealed the limits of judicial power in a young republic, a tension that would echo across decades. Then came a shift. In the Second Republic, the court began to assert itself more firmly. One case would define this era: Seller versus Attorney General.
This case comes out of a situation where when Ghana was transitioning from military rule into the Second Republic, there were certain transition provisions that were made for the executive, right? And one of the articles, if I remember correctly, Article 9, was used to dismiss 568 civil servants. So it was commonly known as Apollo 568. And certain citizens, including Mr. Salah himself, who was a manager at GNTC, decided to take this matter to court. And the court ruled that the transitional provisions does not apply to GNTC. So the court ruled that he should be, he was wrongfully dismissed.
The ruling would become one of the most cited in Ghana's constitutional history, affirming the autonomy and integrity of the judiciary. The battle for independence moved inside the judiciary itself. In Tufo versus the Attorney General, the issue went to the very heart of the institution. Who controls the tenure of a Chief Justice? Can the executive influence the composition of the court?
Just like in the Second Republic, it was at the cusp of a transition from military rule into the Third Republic. And the assumption was that all members of the court from the previous time had to be reverted. Right? And they tried to do that with Justice Apalo as well. But Tufo, as well as, interestingly, I think one of the lawyers was Chachu Chikata and our former President Nanado. They argue that, he's already been appointed a Chief Justice, so they don't need to go through that process again. And the court did indeed stand by that argument.
The Supreme Court ruled decisively, affirming that judicial appointments and tenure must be protected from executive interference. It was more than a legal victory. It was a declaration that the judiciary is not subordinate but co-equal. In that moment, the court defined its own independence. Under the Fourth Republic, the court stepped into the spotlight. With the 1992 Constitution, the Supreme Court took on its most visible role yet at the heart of democratic governance. At the center of national disputes, from constitutional interpretation to election petitions, these were moments that tested not just the court, but the nation itself.
If we look at the jurisprudence of the Supreme Court on the 1992 Constitution, which started after the Constitution came into force in 1993, there was a consistent, deliberate, intentional policy by the Supreme Court to expand access to the court and also to enforce the Constitution in a manner that may not necessarily be convenient for the political class or the executive or the legislature. Now, one of the cases is the 31st December case. When you look at the 31st December case, it's actually MPP versus Attorney General. But the Supreme Court insisted that since we have promulgated a constitution for ourselves and we have decided that we are moving forward, that constitution cannot coexist with celebration of a coup d'etat using public funds. Then it came to the human rights provisions of the Constitution, where, because we are coming from a military background, the attitude was still, yes, the executive authority has to determine the convenience of you going on a demonstration and the convenience of, you have to do it at the convenience of the executive. The Supreme Court in the MPP versus Attorney General again insisted that the Constitution has given that right, and you may just notify the police. So these are just two cases of an intentional decision by the Supreme Court to assert its independence.
Beyond the rulings lies the institution and the people who have sustained it, their duty, their responsibility, their legacy.
150 years in the life of an institution such as ours is landmark and a watershed moment for the institution itself and for the Ghanaian society at large. It is very significant because it is an opportunity for us to look back and reflect on what we have achieved over the years and our current circumstances, and then strategize into the future. And this is aptly captured in the theme for the occasion, Supreme Court of Ghana at 150, honoring the past, celebrating the present, and defining the future.
Over 150 years, the Supreme Court has been more than a court. It has been witness to Ghana's constitutional journey, from colony to republic, from military rule to democracy. And through every era, it has remained a critical safeguard of constitutional government. But history alone does not define the Supreme Court. Its relevance lies in what it does today. Every day, the Supreme Court performs functions that affect governance, rights, and public life. Yet, much of its work happens beyond public view. Today, the Supreme Court sits at the apex of Ghana's judicial hierarchy. It exercises final appellate jurisdiction. It interprets the Constitution. It resolves disputes involving the highest institutions of state. And it serves as the ultimate guardian of legality.
If we have decided that we will practice constitutional supremacy, or the supremacy of the Constitution, then we should have, one may say, a constitutional policeman. Somebody who would make sure that every act, whether it's from the executive, whether it's from Parliament, or anybody for that matter, is brought in line with the Constitution. And the Supreme Court is the court vested with that right to make sure that all that we do as a people fall in line with the provisions of the Constitution. So it follows from constitutional supremacy that we have adopted for ourselves as a country.
The court does not operate in isolation. It exists within a constitutional framework built upon three co-equal arms of government: the executive, the legislature, and the judiciary.
The court has contributed in various ways towards the stability of our society and our country. And so the stability of our constitutional democracy has rested on the confidence that we have reposed as citizens and as politicians in the work of the Supreme Court. And that is why, in crafting the Constitution, the post-independent constitutions, especially from 1969 all the way to 1992, we have had the confidence of investing the Supreme Court with the power to have the final say in constitutional disputes. The general trend has been that the executive branch of government has had a very differential relationship with the court. So I would say that by and large, the executive has been very, very, very respectful of the boundaries, of the court's authority.
Separation of powers doesn't mean we should live in watertight, antagonistic compartments, but rather that we should know how to cooperate. Anything that smacks like disrespect, especially by way of a statement from one institution with regard to the other, must be carefully looked at. I will want to use this occasion to say the final arbiter of all controversies in the Republic of Ghana, as per our Constitution, is the Supreme Court. It's as simple as that. Any controversy of any type or dimension which arises in Ghana, you cannot deliberate and adjudge upon it by yourself. Whether you are the president, you are the chief legislator, or whatever. The fact is, the judiciary is the final arbiter. And all judicial matters, all issues of adjudication belong to the judiciary. The judiciary is not a joke. And that is why men and women who also occupy it must know that what they belong to should be treated very, very respectfully.
The Supreme Court also depends on another critical institution, the bar. Every constitutional argument, every appeal, every challenge to executive power passes through lawyers who serve as officers of the court.
If you look at the bench and the bar, it is described as a mother and a child because all judges started as lawyers. So it is said that the bar is the mother of the bench. We have had a symbiotic relationship which has worked well, and lawyers have always done their very best to make sure that in their advocacy, in their presentation of cases, in the research that they bring before these courts, they try to advance the cause of justice. And you have also public-spirited lawyers who take up cases to also ensure that some rights or some violations are kept, or the law is couched or put in a way that it takes care of some of these nuances.
The effectiveness of justice depends not only on judges, it depends on court staff, registrars, researchers, and administrators who ensure the machinery of justice functions every day.
Some of us benefited from programs whereby the Chief Justice, Akwa, decided to send some of the registrars and court officials abroad to learn more about technology and library science and other spare areas of the court. We built a website for the judicial service, and it was wonderful because there you get a course list when you come into court, the time, the day. It's been prepared every Friday in the evening. So by Monday, it will be on board electronically so that you could access at home. So if you don't have a case, you don't come to court. So this reduces the risk of people traveling all the way from where they're coming from to the central part of Accra to the courts, and their case will not be called. As we went along, to make matter easier for the staff and the judges and the lawyers, because we work hand in hand with them, we mooted the idea of electronic service.
Yet, perhaps, the greatest asset of the court remains public confidence. In a democracy, courts possess neither the purse nor the sword. The authority rests on trust. And maintaining that trust remains one of the judiciary's most important responsibilities. As Ghana evolves, so too must its institutions. The next chapter of the Supreme Court's story is still being written. 150 years is a milestone, but it is also a beginning. The future of justice will be shaped by forces unimaginable to the founders of the court. Artificial intelligence, digital evidence, cybercrime, cross-border commerce, and rising public expectations. How should the Supreme Court prepare?
As you are aware, most of us were born before computer. And then so many of these things that are coming now, cybercrime, nothing are beyond us. Now we are in the era of AI. So people, cyber crimes, cross-border crimes, and other things are committed in such a way that if the judges are also not abreast with the times, they can't handle cases like that. So we are building the capacity of judges technologically. Mm-hmm. Some judges have been sponsored. Our JTI has been actually very much empowered to give training. Most of it are sponsored anyway to our judges. So we are building capacity of judges. And that is not alone, that's not enough. If we don't deal with that of the staff are also included in this capacity building. Okay. So a lot has been done in this area, and it is actually helping.
The future also belongs not only to institutions, It belongs to citizens, to young lawyers entering the profession, to judges who will one day sit on the bench, to ordinary Ghanaians whose faith in justice gives meaning to the Constitution.
For me, the most powerful statement in our 1992 Constitution is in Article 1 of the Constitution. That article says that the sovereignty of Ghana resides in the people, not in the president, not in the parliament. It resides in the people. Those words are often not understood. They are cited, but they are hardly understood. People don't think about it. Sovereignty is the highest form of power. And to say that it resides in the people means that the people are ultimately most powerful. Not the executive, not the legislature, not the judiciary. Therefore, a system of justice must always serve who? The people. That Article 1 is supported by Article 125 of our Constitution, which says that justice emanates from the people. So it's not just the people who are sovereign, justice itself emanates from the people. And so you must have a system of justice that ultimately benefits the people. If justice is not administered to benefit the people, it is not a useful form of justice. Judicial processes which do not serve the people, therefore, are not useful. So judicial processes must be accessible, and that's where we have access to justice. They must be intelligible, meaning that when ordinary people encounter them, they must understand them. And judgments must speak not only to lawyers, but to citizens. Judges must write judgments so that ordinary citizens can what? Understand them. We live in a hugely technological world today. And so technology must also serve the people when it comes to the administration of justice. This means that simple processes like electronic filing, electronic service, and all that must be instituted quickly to aid access to justice. And I'm happy that the current Chief Justice is working on those issues.
The courts will also require reforms, improved access to justice, reduced delays, greater public education, enhanced transparency, and stronger institutional independence.
I and my team sat down and we realized that the main cause of this diminution in confidence in the judiciary was delays in the courts. Cases that come to court, some of them stride years. Even commercial cases that are supposed to be heard within a very short time sometimes took years. So we adopted a strategy to deal with the cases. And we decided to tackle the delays head on. The first thing that we decided to do was to increase the number of courts. And since it is not possible to, within a short time, increase courthouses or infrastructure, we decided to make use of what we had. So we decided on afternoon courts, which are now in place. Now about 30 courts sit both in the afternoon, morning and afternoons, all over the country.
The challenge for the next 150 years is not merely preserving the court. It is strengthening it, ensuring that justice remains accessible, independent, efficient, and trusted. For 150 years, the Supreme Court of Ghana has stood at the center of the nation's constitutional journey. Its history is written in landmark judgments. Its purpose is reflected in public service. Its future will be shared by the choices made today.
We were handed over the judiciary in 1876, and our forebears have done a lot. They have done their part. We are doing our best, and I hope that the future is very bright for the nation as far as the judiciary is concerned.